All right. I'm going to give you a choice. Sometimes I can give people choices, sometimes I cannot. I do believe that you have a drug problem because everything that I see is related to your drug issues.
Yes, Judge.
Court is calling 2019 CR 9540, State of Texas versus Xavier Dante Doxey. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Robert Ramirez for Mr. Doxey, Your Honor.
Are you Mr. Doxey?
Yes, ma'am, I am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxey who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson with intent to damage a habitation or a place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 5 on or about the 12th day of March 2024 in Barry County, Texas. The defendant Xavier Dante Doxey, defendant there failed to conduct himself in a proper and orderly manner before the supervision officer at the Barry County Community Supervision and Corrections Department in violation of condition number 5.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor. That is correct.
All right, is that the agreement?
That is, Your Honor. We would ask Your Honor for the honor to consider lifetime recovery. If that's possible.
All right, so in the motion to violation of condition number 5, what does that mean? How did he fail to conduct himself in an appropriate manner?
My understanding, Judge, is that in the justification, it states that he reported to be under the influence of amphetamines during an office visit.
All right. So has he been to safety before?
No, Your Honor.
All right, will he be accepted into safety?
He does have a history of drug use, Your Honor, marijuana and amphetamines. He did complete state ISS in December of 2021 or March of 2022. And he did complete SATA June of 2023 to October of 2023.
And I'm assuming felony drug court would not accept him because previously I ordered felony drug court.
He was not referred due to being in the SATA aftercare program. Is what it says.
All right. I'm going to give you a choice. Sometimes I can give people choices, sometimes I cannot. I do believe that you have a drug problem because everything that I see is related to your drug issues. I can sentence you to 6 years in the prison, or what I can do is I'll refer you to felony drug court. Maybe felony drug court will accept you because you're not in any other program, or either you're going to safety.
I'll take safety.
All right, so I'm going to deny the motion, alternate amend conditions. To include, the first thing I want is a referral to felony drug court. And then the second, if felony drug court doesn't accept him, then it'll be safety. And there's going to be the UA hotline upon release and 120 sober meetings in 120 days. Why are you not able to stop using? What's going on? Do you have a support system? Do you not have a support system?
I have a support system now.
that was not implemented at first.
And who is your support system?
Just a church family.
All right, your go-to should not always be to use drugs. I understand that sometimes they always say change people, places, and things, but when there's an issue, your automatic response should not be use drugs. If you're having an issue, your automatic response should be, okay, I think I'm gonna go on the path of losing drugs. Let me call my sponsor. Let me call probation. In this court, if you're thinking about using drugs, you know you're not supposed to use drugs. All you have to do is call probation, and if they're not responding, all you have to do is come into court, and you can come into court and say, Judge, I'm on probation out of your court. I'm struggling right now. I'm thinking about using drugs. And guess what? You'll receive help. But if you're just walking into probation, high on drugs, that's not a good look. Do you understand?
Yes, ma'am.
All right. Is there anything else that you need from the court to be successful?
Paper of, from you to recruiter.
I'm sorry?
Think about trying to join the military, so like. any type
Oh,
of-
well, I don't want to step on anyone's dreams, but they may not accept you.
I understand that.
All right. But if you let probation know that's what you want to do, I'm sure they'll have a contact number. And I think if you Google, there's a 1-800 number you can call and you can see if they'll accept you. And because of the fact that it's felony drug court, I'm going to extend him for 2 years. All right. Anything else?
Okay.
But we're off the record. But yes, please do look into the military. Who knows? They may accept you. There was someone who spoke at the felony drug court graduation. He said that everybody told him, you can't be an attorney, you can't do this because of your history. Guess what? He graduated, and 4 years later, he's an attorney. All right?
So,
All right, good luck to you.
thank you.
Thank you, Your Honor.
You're welcome. Yes, he's to remain in custody. All right, who's here on Fidel Escamilla? Court is calling 2024 CR 5540, State of Texas versus Fidel Escamilla. Can I have parties announced for the record for the state defense?
Sharon Thorne for the defendant.
And are you Mr. Escamilla?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
All right. Mr. Escamilla, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as a defendant? Did you review the document entitled Court Admonishment with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Escamilla, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
Are you, that was a slow answer. Are you a U.S. citizen? All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yeah.
According to the plea, 10 months in the state jail facility and there are no applications. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence. All
State officer.
No objection, Your Honor.
right, state, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. First of all, in checking with your clerks, he has 120 days credit. We ask that you give him credit for any and all time that he spent on this. We ask that you follow this plea bargain. I do believe it's in his best interest. We discussed all different options, but at this point, we do believe this is the best interest. So we ask that you follow the plea bargain as stated and grant him his credit for the time.
All right, thank you. Excuse me, sir, in the check shirt, you need to have a seat. All right, the court, as previously stated, is finding there's sufficient evidence to find you guilty. Court is going to find you guilty, sentence you to 10 months in the state jail facility, give you credit for any time served. I'm going to request the therapeutic community. It doesn't increase the time that you're in custody. So for example, 10 months passes, you're done, but they say, he needs more time for his drug treatment. They're not going to keep you because you're in the therapeutic community. It's probably a good placement to you to help you with your drug issues. All right, anything else with regards to sentencing?
No, Your Honor.
Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Escamilla, how old are you?
43.
All right, here's the thing. These cases tend to pile up on people, and before you know it, you're habitual. And at some point in time, even if it's a state jail felony, if you're labeled a habitual, you could be looking at 20 years in the prison. Heroin use, any type of drug use with illegal substance, the people who are selling that, they don't care what goes in it. All they want is repeat customers. If somebody dies, there's always somebody else who's available to use. You understand?
Yes, ma'am. Just for the record, I really never, this is the first time I was using heroin, but like I said, I was on a pilgrimage for a decade. You know, I started hearing voices, and I found when I was taking my brother to his mental health seminar thing, I picked up a pamphlet and it said what to do when you hear voices, and it said challenge them and question them. And so I did, you know, so I've been on a pilgrimage for 10 years, and
Could I have his file back, please?
you know, and like I said, it's the only, without it, in short, is the only way to get granted an audience to be present here, and you know, and with that, you know, and I'm still on it. It's been actually over a decade last year, but because I had to quit the experiment early because of eternity, and you know.
All right, so here's, I'm not a medical doctor,
No, I'm
but
not,
maybe you don't want to be the guinea pig or the
No,
experiment.
I meant, like
But-
I mentioned, I wanted to stop doing heroin, like, but because, like I said, it cost me my parental rights for my daughters. Like I was a single dad for, like, when this incident happened, you know, but like I said, it was intense academic understanding between me and the voices, who I assumed was the Central Intelligence Agency,
Okay.
you know?
And counsel, you believe he's currently competent?
I do, Your Honor. He does understand what he was charged with. He does understand what happened that day, and he does understand he had heroin. So in that respect, I do believe he's
All
competent.
right, so Mr. Escamilla, here's the thing. I'm gonna ask them when they take you into custody to help you with mental health and to help you with drugs through the therapeutic community. When you're released, if you cannot find a place to go, you can always come back to this court and I will direct you to the Center for Healthcare Services and some help with your drug problems. You understand?
Yes.
All right.
That's basically what I've been trying to get.
All right, so you can always come back here. All right? Good luck to you.
All right.
All right. Hello.
Hello, how you doing?
All right. They say that you're doing just okay. And you understand why the reason is just okay and not fully doing well.
Yes, I think it's because I had came out dirty on the UA.
So sometimes people forget certain things. They are sort of far removed from when they were granted probation. You were granted probation on November 19th, 2021. And at that time, I'm sure if it was your first offense, you were thinking, oh my gosh, I could be going to prison for 10 years, right?
Yeah.
And so once people are on probation, they forget the trepidation they had about potentially going to prison, and they get a little lax. You are not allowed to use marijuana on probation. Here's the thing, that's technically not my rules. That's the legislature's rules. If you want to write your legislator and see if they'll pass a law to allow people who are on probation to use marijuana and to drink alcohol, you can do that.
Yes, ma'am.
More likely than not, they're going to say, no, we're not doing that. So when you're on probation, you're on probation. You can't use marijuana. You can't be trying to use the system and say, oh, well, I'm doing CBD
Yes, ma'am.
because I see the CBD places throughout San Antonio. You're not allowed to do that. Do you understand?
Yes, ma'am.
They want to patch you. I don't know how the patch will do with as far as the marijuana levels. I'm thinking more along the lines, you're going to do the UA hotline and they're going to be testing you for levels, and those levels had better be going down and they better get to negative. Do you understand?
Yes, ma'am.
Is there anything you don't understand from court?
No, ma'am. I've been doing everything that I have to do. Is just just a little bump in the road.
All right,
Yes,
that
ma'am.
bump in the road
It
could
could.
cost you 10 years.
Yes, ma'am.
And whenever you get ready to do something that you think maybe you won't get caught or, I don't know if I should do this or not, you need to ask yourself, is it worth potentially 10 years of your life locked up? Okay.
Yes, ma'am.
All right. So what I'll do then, I'm going to alternate in his conditions to the UA hotline.
I was just gonna ask a question. I was gonna say, because I know you hear it all the time, but people are out there, it's because CBD right now is the thing. Because people can't smoke weed, so CBD is the thing out there right now. But I was gonna say, if anything, I could take classes, or I'm doing everything I'm supposed to do.
Oh, we're gonna hook you up with the UA
Okay.
hotline. And here's the thing about the UA hotline, which I love. The UA hotline is random,
Mhm.
but you have to call in every day. And they may tell you,
Oh, I
come in.
have to call?
Yes.
Okay.
They will either tell you come in and do a UA. You never know when they're gonna tell you to come in and do a UA.
Okay.
You understand?
Yes, ma'am.
All right. So Ms. Abrams, we're gonna do the UA hotline until further notice. And test him at least twice a week to see if the levels are coming down. Once the levels are 0, we'll just do the regular UA hotline. Sometimes he'll call, he'll be tested, sometimes he won't. We'll see what happens. Is there anything else he needs?
No, Judge.
All right, don't be that person who's right at the door about to have completed probation and then you want to do,
I was going through some things, but everything's back in order and in line, and I'm doing
Well,
what I have to do.
here's the thing, when you're going through things, your go-to shouldn't be something that could potentially
Yeah, I
result.
take medication, ma'am, so, and I don't want to be hooked on, they want to give me like Xanax and stuff
No,
like that.
here's
I
the
don't wanna
thing.
Take those things.
I want you to hear me clearly.
Yeah.
Oh, okay.
When things are going haywire in your life, your go-to should not be to do things that could potentially result in you going to prison for 10 years. You understand?
Yes, ma'am.
So we're having this conversation. But the next time we have this conversation, you know where it's going to be? Either you're going to have made bond, or either you're going to be brought over from the jail, and it's going to be in the form of a motion to revoke. All right? All right. Good luck.
Thank you.
Sure. Just have a seat. They'll go over new conditions with you. It's been requested by security for security reasons. All right.
In all courts, left side.
Oh, no, this is our court. I followed through with security. It's what security says is best for them. I believe that everybody should stay in their own lane. I tell everybody, I'm not security, so I'm not going to be in charge of security. All right, where are we on this case?
We need a Padilla letter.
Okay,
For it to be able to enter a place.
all right, and does he speak English?
Yes, he does.
Okay. You need an interpreter?
Yeah. Almost better.
What? Okay. I just asked him.
Yeah,
He spoke English.
let's speak, please speak English too.
All right, so here's my question. Throughout these proceedings, are you going to need an interpreter?
Yes.
All right, so for now, he can speak in English, but if he wants an interpreter, I'm going to just make sure that interpreter is always here for him.
In the future,
Yes,
not for today.
no.
Okay.
Oh, because he really doesn't need an interpreter.
Right.
But since he wants to say he needs an interpreter in English to me, we're going to make sure that he has one.
Just for the plea, right?
No, each time he comes to court, we're going to make sure an interpreter is here for him because he's saying that he needs an interpreter, correct?
I'm
Oh.
not sure on your honor. Actually, I'm not sure.
And that's probably nowhere on this question.
Yeah, yeah.
All right. And so with regards to the,
La verdad, sí entiendo inglés, sí hablo inglés, pero no sé hablarlo muy bien.
He
And
says he
he understands
understands, but
it
he
real
doesn't speak
well.
this.
okay. All right, so are you retained? Are you going to see about the immigration issues? All right, Norma,
Judge, yeah, I'm gonna have issues with Odyssey.
Yeah.
I have all the attorneys as hires, so. I don't.
Yeah, I know.
I have to fix that.
I look at it going, I look on my QuickBooks, I go. Ah. that's what
You're right,
it's for money.
you're requesting, Lance is
Yeah.
requesting on all.
all right, so he needs an immigration attorney.
Him feedback.
I have the number.
He has his
Okay.
card.
All right, and then did you give them all discovery?
Yes, Judge.
Yeah, I have, we,
And I would say it has given them.
Okay. All right, Norma, reset this for 45 days, and that will be your plea deadline date. If your attorney wants to come over sooner, because maybe he has the Padilla letter, you can always ask the court to put him on the docket sooner.
okay.
I think it's July 22nd.
All right, we'll be back on July 22nd.
Ah, pero podemos unir antes, ya que te la carta de Padilla. July 22nd.
Yes. Bradley Galbon. Hello.
And just for the record, Judge, his name is actually Lon.
Galan.
They indicted him on one case correctly, the other case they acquitted him.
Now, on both cases, they have him as Galbon.
They should be correct.
One indictment has Galan, one has Galvon.
All right.
So we asked for an immediate acquittal.
Let me see. All right. So, Mr. Bradley T. Galan, why were you late for court?
I just didn't make it here on time.
All right, so I require everybody to be here at 9. That's when docket starts.
Yes, ma'am.
So you know where the court is now. You shouldn't be late again. You understand?
Yes, ma'am.
All right, so where are we on discovery?
Judge, brought to my attention, I believe it was something that was maybe slipped through the cracks last time, but today I went over many of the warrants and affidavits that we need to request, or I have requested. I sent an email off, and in fact, before you approached, I asked, let me get this email out. And I believe that I have everything requested, just requesting time for that. It's several different things. There's a Google, and there's a Google geofence that that Texas Parks and Wildlife Department uses. And so it's a little bit more than the average case.
Oh, well, I always tell people think as a judge, you should know everything. So I'm looking at the charge, the taking of certain wildlife. Yes, so I'm gonna have to look up and see what level felony this is.
That's, I believe, a third degree.
All right, so I'll see, we say, I like when we say believe, so you can, so I'm gonna have to look that up myself. All right, so it's gonna take some time to,
Well, I mean, what I'm saying is at least
State
30 days
jail,
for
I
discovery purposes. I mean,
Mhm.
I've dealt with Texas wildlife parks, whatever you call them, and they're really good about documenting everything, so I'm assuming that's what's the case. I mean, and I should be able to get it since they'll probably be in contact with me pretty shortly after this.
all
I
right,
think
so,
giving myself,
so how much time are you all asking?
I'm asking for at least 30 days, if not 45 days.
Okay,
I have no objections to that, Judge.
all right, so Ms. Ferguson, can you give this a 45-day reset?
I can do the 22nd or 23rd.
July, correct?
Yeah, I'm gonna look that up, so I'll know.
23rd.
So we're to recall for July 23rd for discovery?
Yes.
All right, is there anything else?
No, Judge.
All right, and I'm gonna look that up to see, so we can turn the, I believe, to, we know.
We know.
All right, so both will be set on that date. And I'm assuming there's the labs are in, since the drug case was indicted. All right. Is there anything else? All right, once you sign the reset form, you're excused. All right, who are the parties on the Asia? Harrison?
Judge, I'm present for her. I was spoken with probation. I'm gonna look up something real quick if we can.
Sure. Well, I mean, work up something as in what?
Judge, it's a motion to early term,
Mhm.
and I know probation wanted to send a message just to make sure something was done about that.
Okay,
And it was my fault. I just let them know we had it.
okay, no problem.
I was just gonna reach out to the probation officer, to see if he had any information to provide to the court on the defendant's status.
Okay, all right, thank
It's
you.
my fault. I just-
Oh, no problem. All right, Britta, how far is Georgetown from here?
Like this past office. It's about getting to Austin is part of it. Well, I hit like 80.
Yes.
Yeah, I go there. Yeah, so it's not that.
So how long?
Maybe about. Depends on what. You go 35 or I go 35, you know?
Because I do not do toll roads.
Well, I wouldn't do the toll. Judge, I don't do toll.
Oh, I don't either, because I figure taxpayers are already paid for the road.
Yeah. No, it's just.
Why are we paying it again? That's just one of my things.
I think once you get through Austin, it's not that far. It's just getting through Austin.
Well, I will tell you, whenever I have to drive through Austin, I just take it as an opportunity to be stuck in traffic, to people watch.
Well.
Because I don't think anybody's going to do anything about the truck. You know what I think? I think people are going to continue building more and more freeways. It's going to end up being a 10-decker or something. When an accident happens and it falls over, then somebody's going to say, we should do better with public transportation.
Once you get through Austin, it's. Yeah, once you get on the other side of Austin, you're fine. You're fine. It's not that far from.
I just use Austin as an opportunity to sightsee. So, yeah.
You gotta have lots of patience in Austin.
Oh, yeah. Because, I've found, I've driven through Austin early AM, like 3 AM,
Yeah.
traffic,
Yeah, it doesn't matter what time you go.
6 AM traffic. The only time I've driven through Austin and it wasn't a problem, Christmas Eve.
Oh, you.
Hello.
May we approach?
Yes.
All right. We have an agreement worked out. Currently, his client is indicted for DWI with child.
Mhm.
We're gonna do DWI with child, reduce that down to a misdemeanor, then do an endangering. However, we don't have a file for an endangering case. Come to the court with what solutions were. We tried to ask for an indictment waiver. However, since that case is already, the DWI with child's already indicted, they weren't able to give us an indictment waiver number.
Mhm.
Kind of coming to the court with what solutions we can have. We could always create a file this afternoon and then come back tomorrow and have two separate files and do the indictment waiver on the new file.
Mhm.
Or unless the court has another option.
I think that would be probably be best, because I think if you were to do it as different counts, that's too much of a substantive change.
Correct.
Judge, just, we're gonna take the deal. If we could just have some time to do it, maybe recall it after the new year if possible, and not a very old case, it's case 2022, isn't it?
Yeah, I think just.
Just
Which
to make
case is
sure-
this?
It's the, we've been coming back for the last couple of days, mainly because. we were
What's the,
getting
what's the
this,
person's name?
Apolinad.
April. I think right, April.
Yeah. We've been coming back, Judge, because we were hammering out the deal and finally.
Since August. So even though it's
I'm
20,
just saying it's worked out. It's
I-
not one that.
all right,
Yeah.
because August 22 is a long time for this court.
I'm just saying we haven't worked out. It's not,
All right.
rather than have everybody stress over it.
Oh, nobody stresses here. We all are very calm and how we proceed, and it's all fluid.
So yeah, so I thought about just amending the indictment today. However, I think that might be too much of a change.
That is. Brenda, do you see what?
Check on the recall date.
All right,
We have been working diligently to get to this point.
all right, Ms. Apolinar, if you can come forward. All right. Ms. Apolinar, your plea deadline date is going to be, on this case, is going to be January 9th. The court will not consider any plea bargain agreements after that date without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, if you can give her a January 9th date.
Thank you, and we'll have the paperwork done by then. I'm sorry, I should have figured out these issues prior to this.
No, no
No,
problem.
we just figured it out. Saying,
Oh, that's right.
Yeah.
But I knew what I was gonna do on Sunday. I should have figured it out.
Okay, why were you not working on Sunday then? Okay. All right, Ms. Ferguson, we'll give you a reset form. All right, Tyler Ashbaugh,
Judge.
good morning. All right, today is the plea deadline date.
Yes, Judge.
Yes.
I've actually filed a motion for inspection of physical evidence. I know it's the plea deadline. We're not inclined to accept the offer at this time, but I do have some ongoing discovery matters that I'd like to bring to the court's attention.
All right, what ongoing discovery matters?
So I have a motion for inspection of physical evidence. Number one, we, and the state does not have any objection to this. I would like for our investigator and expert to have access to the white Nissan Rogue that was seized in this vehicle
Mhm.
for the purpose of downloading the event data recorder data from that night. I believe it's going to be material and possibly useful in our defense, Judge. And then also just to inspect all of the physical evidence that was seized or documented by the police from that night. I believe the state will probably be offering most, if not all of that evidence into a possible trial. And some of it was a little unclear when I'm going through the reports to see, is this a casing? Is this a bullet that's marked? And I don't want to take any chances. I want to know exactly what each documented piece of data is and lay eyes on that. As I said, Judge, the state doesn't have any objection, but would like to be present, which I understand. So I think that we're going to coordinate a date where myself, the prosecutor, and this detective on the case can all be present and knock out these things. I know that the state says that they have a murder trial next week, but they're gonna try to reach out to the detective and schedule a mutually agreeable date for all of us to be present. So we would ask for a 45-day reset just to take care of these matters, Judge.
All right, so I see that you were substituted in April,
Yes,
because otherwise I was going to ask you, why are we just discovering this now? But I see you were recently substituted in.
that's correct, Judge. And there's a lot of discovery on this case. I've been trying to go through it diligently, but there's just a ton of information.
All right, so when is this going to happen? The inspection of physical evidence and the download of the device?
So Judge, I plan on reaching out to the detective today, trying to hear back. I don't know when the detective's duty days are. Once we hear a time frame, I think defense and I are gonna throw out dates just so that we can give options to the detective. And that we can schedule time for all of us to go into this, and try and knock it out in one day.
All right, so here's the thing. I'm gonna give you all a reset till July 29th. Everybody needs to have done whatever they needed to do. All right?
Understood, Judge. Thank you.
Yes.
Wait, hold. Oh, okay. My client was just saying that July 29th is his wife's due date. If we could do maybe the week before.
Does
Is
she
that
really
okay?
want you there? Are you gonna pass out? Are you gonna be helpful?
Yes, I will be helpful.
I don't know. I've seen plenty of
She asked me
videos.
the- she asked me the same
Yeah,
question, but
I've seen plenty of videos where people just pass out. They're not helpful. All right. July 22nd, is that enough time for everybody?
That should work, Judge. If there's some issue with the detective, if, they're out on vacation or leave, if there's something else that's preventing us from going by that date, we'll let the court know.
Okay. Well, congratulations on the soon-to-be new baby. Babies have their own schedule,
they do.
so realize that you work for the baby.
Maybe
Once
make
the
out a
baby is
week early
born.
and be on that day too.
Yeah.
I was thinking. Yeah.
All right, so we'll be back on July 22nd for the discovery issues. And do you have the motion?
I do, Judge, here. And there's the order's the last page.
All right, thank you. All right. They'll give you a copy of that,
Thank
the
you.
order,
May my client be excused?
once he signs the reset form.
Okay.
Sure.
It was filed yesterday, but I don't know that it's. Okay. I don't know that it's been accepted yet. I haven't checked this morning. Okay.
All right, the court is calling 2021 CR 7282, State of Texas versus Charles Garley. Could I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Mario Moreno for the defendant, Your Honor.
And are you Mr. Garley?
Yes, ma'am.
All right, defense has filed a motion for continuance. State, have you a chance to review that motion?
I have not seen it, but we're not in objection to it, Your Honor.
Why not? This case has been going on since September 2021.
Your Honor, I think it's just two lawyers from the same firm that are just substituting out for one another. So I don't anticipate any delays. There's no discovery between both lawyers that would necessitate any type of delay.
All right, anything you wish to say?
Well, yes, Your Honor. Well, first, I'd like to introduce myself to you. I believe you and I have ever met, Mario Moreno. Mr. Nathaniel Navy and I do work.
All right, you all need to whisper.
Nathaniel Navy and I did work in the same firm with Dunham and Jones. Mr. Navy is no longer with the firm. I filed a motion to sub-counsel in this case, and that should be with the court's file as well. My understanding today was that it was set for a discovery compliance hearing of some kind and also potentially a jury trial. So because of my recent substitution, I would be needing more time to prepare for trial. Additionally, in discussing with the state, I did find that there were some records that we were trying to subpoena or have the state provide in regards to an investigation that was taking place with these officers related to this charge.
That's been going on since September 30th.
Yes, Your Honor. And that was in discussing with the state, it seems like they are attempting but have not received that and provided to the defense counsel.
Judge, we've subpoenaed the records. We spoke with City Attorney Jim Cobb. He said that he would just need a day or two just to get it together. He also was going to file a motion to quash, which I don't believe he's done yet. Or if he has, it's about to happen.
Then it seems like the state may not be ready for trial. And maybe the state needs to file a motion for continuance.
We can, Your Honor.
All right, state, you want to file a motion for continuance?
We will, Your Honor.
And then the court will hear it.
Yes, sir.
All right, just have a seat. All right, Christian Smith, if you'll come forward, please. Hello. Thank you for dressing appropriately for court. Your attorney is actually out of county. So we're going to recall this for next week. Are you employed? What is your work schedule?
Work this morning, but flipped around.
All right, so what's your work schedule?
I usually work Monday. I usually work the whole week, but this week I work Monday, well, today. And next week I work Monday, Wednesday, and Thursday.
Okay, so next week, would Tuesday be a good date for you? All right, so we'll put you next week on Tuesday, the 11th. All right, once you receive your reset form, your excuse. Thank you.